Hi, my name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2021 Harlan Institute Virtual Supreme Court Competition. This year, we're mooting the case of New York State Rifle and Pistol Club versus Bruin. This is the semifinal round, and we have match number 7. From the Baldwin School in Pennsylvania, we have Win Conger and Lighthouse Wu. And from the Charles Herbert School in Bowie, Maryland, we have Daniela Nat Davies and Amber Ware. Petitioners will go first, and they will have 10 minutes to begin. Petitioners, whenever you're ready, you may start.
Okay, Mr. Chief Justice, and may it please the court. My name is Lighthouse Wu, and alongside my co-counsel Win Conger, and we'll be representing the petitioners in today's case of the New York State Rifle and Pistol Association versus Bruin. Would the justice like a brief statement of the facts?
Yes, please.
In 2016 and 2018, petitioner Robert Nash and petitioner Brendan Koch both respectively applied for a concealed gun carry license. So both the petitioners presented backgrounds of extensive firearm experience, and both of them submitted proof of completed safety training courses. Neither of them had any criminal history of note. Both were motivated to possess arms inherently in the name of self-defense. However, both of their licenses were ultimately denied under New York Penal Law 400, as the licensing officer subjectively deemed that neither of them provided a proper cause. Today, my co-counsel and I seek for the court to strike down the New York public carry regime, because not only does it severely restrict the most fundamental right of Second Amendment, the codified right to self-defense, but it excessively burdens those who wish to exercise said right with the required presentation of an extraordinary need.
After all, under the precedent of Heller, this court ruled that the language and intent of the Second Amendment principally guarantees the individual right to possess and carry weapons in case of confrontation to all citizens of the United States, a pre-existing right which has long been codified under both constitutional jurisdiction and the Second Amendment's historical legislation.
If I could jump in for a second, Counselor. What exactly did Heller hold? I just want to make sure what you just said and what Heller held. I understand your position.
Of course. The holding in Heller was that was in the individual right to carry a gun, to gun carry.
Did Heller concern carrying a gun on the streets?
The Heller concerns the carry of gun in any traditionally lawful uses. They gave the specific example of self-defense within the home, but under traditionally lawful purposes, this can logically be extended to self-defense of the family of the person, notwithstanding within the home specifically.
Okay, so you're looking to extend Heller from the home to outside the home, is that right?
Correct.
Okay, all right, go on, you can proceed.
Thank you. Even before the time of the founding, to keep and bear arms in the name of the public defense was deeply enshrined as a longstanding principle in both American and English common law, to the extent where it was synonymous with the fundamental right of the people. As McDonald versus City of Chicago further clarifies, it's clear that the framers and ratifiers counted the right to keep and bear arms among those fundamental rights necessary to our system.
Okay, counsel, I'm going to interrupt you. You speak in generalities of what the framers thought, but I mean, what is your best piece of historical evidence that supports your position here? Counselor Wu, if you could speak to that.
Okay, both state constitutions at the time of the founding and the 1689 English Bill of Rights, they are both like very long time ago, but they both served as a vital influence for the Constitution. They are historically enabled, they enable the citizen possession of arms and for the purpose of self-defense. And these laws, they are suitable, they are saying that those, for the purpose of self-defense, they are as suitable for the citizen's condition as allowed by law.
Okay, sure. But Ms. Conger, what do you do with the Statute of Northampton? That seems to support the respondent's position in this case?
Well, Oh, we chose to interpret the codified right of the Second Amendment and in the framers' intention, also based off an earlier draft of the Second and amended, which dictated that a well-regulated militia composed of the body of the
What about
people,
the Statute of Northampton?
considering the statute of Northampton, and we still believe that in the framers' intention and at the time.
How do you read the Statute of Northampton? Your mind, what does it say?
We read the Statute of Northampton, and in that it claims that civilians and carrying weapons in public is a danger, or sorry, is a public danger. But actually, we would argue that in the interpretation of the Second Amendment, and the use of weapons by the public has been used inherently in the name of self-defense.
The core of
Yeah.
the Second Amendment is just to grant the common public a right to exercise their
But
self-defense.
but the Statute of Northampton says you cannot carry in public. Is that what it says?
The Statute of Northampton,
It's a very old law. that
Oh, it's
doesn't-
old. I agree, it's old. But what does it say? Old things say things.
the Statute of Northampton claims, I believe it claims a prohibition on civilians carrying weapons in public. But we chose to interpret the Second Amendment as our fundamental right, that even while, or that in opposition to the Statute of Northampton, the Second Amendment fundamentally supports, or it's the Constitution and the founders' intention, and that weapons.
So,
and-
counselor, did the Second Amendment expand the right to bear arms, that which existed in England before the founding, or did it maintain the same level?
We do think the Second Amendment expands on the basis of the English Constitution because it guarantees, it connects the right to self-defense with a standing militia. But then as the history progresses, we see that we interpreted the clause that described militia as every individual citizen has the right to access.
Let's change gears for a bit. So Heller talks about sensitive places, right? The government can ban arms in sensitive places. So think of like a school maybe, or a courthouse. How do you understand this phrase sensitive places? How should we define it?
Yes, so sensitive places, it's a really long-standing tradition, like the regulation of carrying arms in sensitive places. They can include, as you said, Your Honor, daycare centers, playgrounds, all those places that either the common public doesn't have usually won't have an access to, or it's that a truly restricted place.
So anywhere where children might be found would be a sensitive place?
We cannot say that anywhere children would be found would be a sensitive place.
Then what's the standard you're going to use?
The standard for what constitutes a sensitive place has been continuously defined and redefined in historical precedent, but it constitutes a long-standing regulation of the Second Amendment, where it's a public place. While there are general principles, certainly, it's a public place where arms carry.
What about the subway? Could you carry in the subway?
We could carry.
Is a subway a sensitive place in New York City?
The
No.
subway is not a sensitive place.
No, because it's a public place, but it shouldn't be a sensitive place because the common public has access to it.
What about Yankee Stadium, where 60,000 people are sort of squeezed into a baseball stadium?
Yes, it's still not a sensitive place because.
What
again,
about on the campus of a college in New York City?
I feel as the campus of a college in New York City would not constitute a sensitive.
So what is a sensitive place then? Is it just a preschool? I mean, what you're holding your position, which I appreciate, but what would be a sensitive place?
Again, the definition of sensitive place varies from.
I'm asking New York City. I'm asking you in New York City, what would be a sensitive place that you cannot carry?
Okay. As in, what would be some general principles we could uphold as a sensitive place?
Or do you want us to fines
Give me an example. What would a sensitive place be other than a daycare?
other than daycare.
Yeah, what would an example be?
An example would be like a government agency.
Okay,
Or-
what about, you know what, you have 30 seconds left. You can just sort of wrap up.
Okay. We would constitute that sensitive places are a longstanding restriction on arms carry, and while their definitions have varied through history, the New York public carry regime differs from sensitive place restriction in that it unnecessarily burdens the petitioner's
Yes.
exercise is in a public place.
Yes, it doesn't matter whether the place is sensitive or not, because we are arguing today about the right of the petitioners.
Okay, excellent. Right on time. Thank you so much. Okay, if the respondents can please come back on camera. And counselor, you have 15 minutes. Whenever you are ready, you may begin.
May it please the court, my name is Amber Ware, and I'm here with my co-counsel,
Danielle Lynette Davis.
and we are here as the respondents for the case New York State Rifle and Pistol Association versus the Superintendent of New York State Police. We are arguing the question whether the Second Amendment allows the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense.
We argue that the Second Amendment does allow the government to prohibit a law-abiding person from carrying handguns outside of the home for self-defense because there needs to be probable and reasonable cause for carrying and bearing arms. Today, we will work to further support the law put forth by New York stating that there must be a special need for self-protection through the means of carrying and bearing arms. In order to support our argument, we'll be referencing the precedents of McDonald versus City of Chicago, United States versus Miller, Anderson versus Mallory, and Babinetz versus Police. We are arguing that the Second Amendment makes a clear emphasis that a well-regulated militia has the right to bear and keep arms. This does not refer to the everyday citizen because militia refers to well-organized citizens with little military training. As a petitioner does not fit this criteria, the right does not ascend. Our next point addresses strict scrutiny. We argue that New York's penal law specifying firearms was constitutional due to the compelling and substantial government interest of protecting its citizens. The court should dismiss the petitioner's claim as moot because of the specific distinction and the clarification for the Second Amendment and who it extends to. In the United States Constitution, the Second Amendment states that a well-regulated militia, being necessary to the scrutiny of a free state, the right of people to keep and bear arms shall not be infringed. But with that being said, the most important part that needs to be addressed is what exactly the amendment means, the limits and circumstances that apply.
All right, Counselor, if I could just jump in for a minute. So I'll ask you the same question that I asked the Counselor on the other side. How do you read Heller? What did Heller actually decide?
Heller decided how you could hold guns, but the main purpose of Heller was within a home. So you have the right to bear arms within your home. It doesn't mention in public.
Okay, good. And so this question is where, if I can, for a minute. Right. So Heller discussed the right to bear arms in the home. I agree with you. I think you're correct on that point. But Heller also said that the government can restrict carrying in sensitive places, right?
Yeah.
Doesn't that suggest that some places are not sensitive, that you could carry in those other places?
That does suggest that, but sensitive places can be anywhere, and you never know how close you are in proximity to those places. So you should just take it as a whole that you shouldn't carry guns outside because.
Okay, so Ms. Ware, let me ask you this question, please. Do you think that the Second Amendment protects any right to carry outside the home at all? Is there any right at all to carry outside the home?
The Second Amendment doesn't necessarily extend to anywhere outside the home because you have to think of the general population.
No, you answer my question literally. Is there a right to carry outside the home? Yes or no?
Yes, depending on the area.
Okay, so could the government ban carry altogether under all circumstances everywhere, Ms. Ware?
It will have to, if they were to choose to ban it everywhere in any circumstances, it would have to go to the process of a constitutional reason as to why it's banned everywhere.
Okay, good. So let me go back to Ms. Nat Davies. Let me ask you this question, please. Let's say New York says that the entire island of Manhattan, all of Manhattan is a sensitive place. Could they do that?
If they have enough cause to say that it's a sensitive
Oh,
place.
to use the example before, their children live on every street in Manhattan. Every place in Manhattan, there's some kid living nearby. Could they ban carrying the entire island of Manhattan?
I do not think that they could,
Okay, why not? Tell me, please.
because like I said previously, you do have the right to carry arms inside of your home.
Mhm.
And I don't think that's something that should be taken away from you. Neither is that being taken away from the petitioner's case. And so if they were to say that the whole of Manhattan is a sensitive place, that wouldn't be fair, because people have the right to defend themselves in their homes.
Okay.
And just
So what if they said you can carry in upstate New York where it's more, rural, it's not very dense? Would that work?
I think when discussing the specific locations, it'll all have to go back to whether it's ruled as constitutional or unconstitutional based on their supporting reasonings for why they decided to go forward with that act.
Okay, very good. You may proceed, counsel, with your argument.
Okay, so in a previous case, Heller, that an individual's rights to bear arms has its limits. It doesn't necessarily give someone the right to keep and carry weapons they choose for any purpose. It is easy for the majority to rationalize an individual owning a handgun for self-defense, but they conceded that the certain individual should not own firearms. States can also limit where guns can be carried. Bans on weapons in
Counselor,
schools.
let me interrupt you. So in your brief, you say that the petitioner's reason for getting a concealed carry license in general just is not logical. Can you explain upon this viewpoint?
It isn't logical because he said that he wanted to defend himself from home robberies. And if you want to defend yourself in a home robbery, then you should keep your firearms and your weapons in your home, because that's the place that you want to defend yourself in. It's not necessary to bring it anywhere other than your home if that's the case.
So let me ask a follow-up. I mean, we're all adults here. We all walk around. Sometimes we're out late at night, and things can happen. We don't know in advance when bad stuff will happen to us. That's just that. I mean, that's an obvious premise. Why should the plaintiffs in this case have to tell you with such precision what they're afraid of? Why is it enough for them to say, we are worried that something bad might happen, we want to defend ourselves? Why do they need to have such precise responses?
If I could answer for my co-counsel, I
Please.
think the main problem that New York would like to address is the fact that they want to keep their general population safe. And of course, everyone wants to keep themselves safe. They don't know what's going to happen, and they want to defend themselves. But when you think about the law as a whole, they also have to make sure that everyone in the entire state is safe. So the law basically goes to whether one individual's specific self-right in a hypothetical situation is more important than if everyone else is going to be attacked.
Counsel, I don't think this court is contesting whether or not New York has a an interest in protecting its citizens, but I guess we're concerned about whether this is the only way New York could do this. So if we could talk scrutiny for a second, and this is for Ms. Nat Davies, what tier of scrutiny applies here, and do you meet it or not?
I think that the strict scrutiny applies here, because if we're referring to the general population, then we need to keep everyone safe. And if certain people have weapons,
So why strict scrutiny and not intermediate scrutiny?
because this is the welfare of the population of the citizens in New York.
Right, but under strict scrutiny, right, the compelling government interest needs to be the least restrictive means, meaning there is no other way that the state could further its compelling interest. So are you telling me there is no other way that New York could have done this? New York couldn't have just simply instituted wholesale background checks for everybody? And we have to go through this magistrate and this whole check system with the specificity? Counselor Ware, if you could answer that.
So when discussing going through and looking and the background of everybody in the entire New York, it seems very unnecessary when there's an easier route as to just laying these restrictions on carrying guns outside your home. Of course, they're not infringing on your right to have a gun inside your home for self-protection. But once you're in a public area, there is more stipulations. And thinking about New York and how big New York is and the population in New York, it's a lot harder to say, okay, let's just look at a background check for everyone. Those background checks can be proven to not always upstand themselves because there are people who have guns who use them for wrong reasons. And you can also think about the amount of people in New York that'll be
Right,
affected.
but don't those people who use the guns for the wrong reasons just forego the whole government thing altogether and get their guns illegally? I mean, we're
No,
talking
that's
about
not
they
always
don't.
that's not always the case because there
So
are
someone
people.
who knows they're going to commit a crime is going to go through the arduous process of asking a magistrate someone with the government so they can get their name on record right before they're about to commit a crime.
Well, they might not know that they're about to commit the crime. Not all crimes are already planned. There are crimes that are done on the moment. There are crimes that you don't intend to do, but in that moment you're heated and you're upset. And in the case of self-defense, you're probably going to have high emotions that make that, and you have a split second decision, and you just decide that you do want to take matters into your own hands, which
But
eventually will cause other people to get hurt.
let me maybe change gears for a second. So I want to go back to the question of a scrutiny, right? Some of the lower courts have said intermediate scrutiny governs Second Amendment claims. Why would you not go with intermediate scrutiny? It's easier for you to win under intermediate scrutiny.
I think that for this is strict scrutiny because of the severity of the individual having a gun and how many people can be involved in and possibly hurt if they have that gun. And it's a compelling interest because it's so many people that are being affected. When New York decided to create this law, they had the intention of the entire general population, which means that it's more intense than intermediate scrutiny.
Yeah, you may proceed with your argument.
Well, going into our second main point, historically, America has followed the same restrictions for the Second Amendment, directly relating to the fact that New York is well within its rights of strict scrutiny to set policies related to concealed carry of firearms and public laws. According to strict scrutiny standard of judicial review, based on the Equal Protection Clause of the 14th Amendment, governments may only pass legislation and certain laws to their compelling government interests. This was a policy created by the United States Court with the intent of protecting rights given by the United States Constitution. As a result, the government that wants to generate and apply these laws and the policy has the burden of proving that the policy is constitutional. If this policy was ever presumed unconstitutional, the courts would have the responsibility to prove and rule this law unconstitutional. We approach the court today to further attest that the gun laws of New York State law of penal law are constitutional and align with the scrutiny requirements. The concealed carry laws explain that in order to carry.
Counselor, I'm sorry for interrupting, but I'd like Miss Nat Davies to speak to how she reads. I asked your friends on the other side about the Statute of Northampton, but how do you read the Statute of Northampton and how does it apply in this context?
The Statute of Northampton that's mostly for. Can you rephrase your question?
Right. How do you read the Statute of Northampton, and in what way does that have an impact on this case? Right. It's a really old statute from England, but how does that apply here? How can that inform this court?
The Statute of Northampton encouraged that for robberies and trespassers, and that would apply in this case because the petitioner is claiming that they want defense for home robberies and self-defense in their home.
I think we have some connection issues.
I think
go ahead, please.
I could pick up for my co-counsel. Basically, in a few words, the Statute of Northampton is saying that you can't carry in public because of the danger that it brings to the public, and you want to make sure that everyone in the public is kept safe.
Okay, you
You
have about a
can
minute left.
continue.
You can proceed. And I think your partner froze. I'm sorry.
It's okay. So going back to our argument, we approached the court today to attest to the fact that New York's concealed carry laws were constitutional. We also attest to the fact that they are aligned with the strict scrutiny laws because they were developed with New York's compelling government interests to protect their citizens. Throughout history, stipulations to protect the people have continuously been made for firearm laws, specifically concealed carry firearm laws. Petitioners approached the court today to argue their Second Amendment right of self-defense has been infringed upon, yet their rights have not been violated. New York is still well within its right to protect its citizens by creating restrictions that are supported by the common law of defense. An individual may appeal the need to protect themselves only when intermediate, a certain or immediate suffering would be the consequence of waiting for the assistance of law. In this case, there is no immediate suffering for them having to carry their firearm. There's always the police or law enforcement that they can contact if they need to in certain situations. For the reasons explained, the respondent respectfully asked the court to do. Yes, Your Honor.
Okay, time's up. Thank you so much. Thank you so much. And the petitioners, please now 5 minutes rebuttal time.
All right, yes, Your Honor.
Whenever you're
We
ready.
would like, yes,
Proceed.
we would like to address the issue that has been discussed by the respondent, and they've already defined what is a heightened scrutiny. And we would like to point out this level of scrutiny really depends on two main points. One is that it begs the question, does it impact the core of the right, which is the Second Amendment right? And how severely does it impact the core of the right? So in this case, and also defined by the lower court case, Jimenez, the New York penal law impacts the core of the right to self-defense because it severely burdens the petitioner's right to access to self-defense. And they have the burden to prove themselves as to have a proper cause, which is totally based on the subjective judgment of the licensing officer.
But let me interrupt you, Ms. Wu. Isn't it common that government officials exercise judgment and discretion? Is that so unusual? I mean, whenever you do anything to the government, they can exercise judgment. It's not bias, it's not discrimination. They're not saying you're not giving it because you're a woman or your race, whatever.
Mhm.
Why is it so bad for government officials to exercise discretion?
Yes, because in the New York penal law, the definition for a proper cause is so vague that any government official can easily subjectively deem what it is. Like,
So
for
what standard
example,
would you use? In other words, what standard, if you were the governor in the legislature, what standard would you write?
if I were the official, I would just abandon the clause that demands for a proper cause. I
You
found
don't
it
think there
should
can be any cause whatsoever? What standard would you use? Someone wants like a gun license to carry. What standard would you use?
I would use what would say as to change New York law into a shall issue rather than a may issue, because in the New York penal law, it has as if it's saying that we will not grant you this license if I find you not proving enough of yourself. But what in reality I would find it more reasonable if it's I as a licensing officer would have to have the burden to prove you not exhibiting a good moral character. In that case, I'm not granting this license.
Sure, but Ms. Conger, if you could speak to this, don't a number of good cause laws, so-called good cause laws, have a well-founded root in the American legal system? It's my understanding that they do.
While good cause laws do have historical precedent, we feel as though the Sullivan Law differs in that it excessively and unreasonably burdens the petitioner from exercising their Second Amendment codified right of self-defense. And to the extent where the New York penal law is more to the extent of a regime or the demonstration of a typical need to the satisfaction of a government and official is necessary even for the exercise of one's fundamental constitutional right. And we feel this directly infringes upon the Second Amendment.
Let's switch gears real quick. Do you agree with your friends on the other side that strict scrutiny applies?
Yes.
And do
We
you-
argue for heightened scrutiny.
It's
Well,
my understanding.
Heightened scrutiny or strict scrutiny? 'Cause those are not necessarily the same thing.
Yes, we argue heightened scrutiny on the hymnus.
Okay.
And what is the test for heightened scrutiny that you're proposing?
Could you repeat your question? I'm sorry.
What is the test for heightened scrutiny? What interests must meet some narrowly tailored thing? What's the test for that?
I think I've already stated that the definition of heightened scrutiny is because this new appeal law severely impact the core of Second Amendment right.
Okay.
And-
You have about 30 seconds left if you want to just summarize and wrap up.
All right, would you like to continue?
Of course. Or because the New York regime places is undue burden in on the petitioners to prove that they may access their Second Amendment right under the original intention of the Second Amendment legislation of self-defense at the time of the founding. And we argue that the New York regime's burden and on the individual's inviolable right aid to self-defense is unconstitutional. And we pray that the court uphold the principal ruling of the Second Circuit that states cannot deny a law-abiding person a license to carry a handgun outside the home under the Second Amendment's protection in this court's precedent.
That was a really long sentence. Okay, you got it in. All right, thank you.
Sorry, I went a
Thank
bit
you.
over.
All right. Woof. I was like, okay, wait for the period, Josh. All right. Congratulations, both of you. Everyone, please come back on camera, please. I need to congratulate each and every one of you. You are all high school students, 15, 16, 17 years old. You are performing at the level of law students. Truly, I have two law students right here on my panel. You are performing at the level of any law student right now. You could go to law school tomorrow, walk into a moot court competition. You have poise, you have composure, you have command of the material. When we throw these hard questions to you, you don't get thrown off course. Say yes, Your Honor, but, or no, Your Honor, but, right? You pivot from your weakness to your strength, right? You know the question I'm getting you is designed to throw you up, right? You know we're trying to give you a hard time. We're not asking these questions trying to help you out. We're trying to hurt you, right? And it doesn't matter, right? You're able to simply pivot from a weakness to a strength, and that's a remarkable talent. You're sitting here arguing about the English Bill of Rights, the Statute of Northampton, right? You're talking about precedent. You're saying different types of scrutiny. I didn't know what any of this stuff was when I was in high school. I couldn't tell you what scrutiny was. I don't know. It just gives me so much hope and joy to see people like you take such passion for constitutional law and dedicate your time, your energy on a Sunday morning, no less, to argue this. So it brings me much joy. I just want to say thank you to each one of you sincerely. And you're on to great things. You have all bright futures ahead of you. Ashley and Reed, any other feedback you want to give to our students?
Yeah, I think y'all did really good. One thing I wanted to mention though, and it's something I didn't know when I would go to law school, so it's maybe something y'all didn't know either, is that if you're not sure about a hard question that you get, that you are able to say, I don't know. You don't have to answer everything, and you don't have to just come up with something on the spot. And that's something I was aware of. So I always think that it's something, to tell people, because it's important to know and not just have to make something up on the spot, because it does hurt your credibility. Not saying that that's something y'all did, but just, going forward, something to know. But overall, I think y'all did really well.
That's really good advice. Thank you, Ashley, for that. That's excellent advice. Because trust me, you're gonna get a question, maybe not this round, maybe next round or another round, where you're gonna have no idea. And the worst thing to do is just start making stuff up, because then the judge will tear you apart. It's like, really? Is that what you think? That's not the right answer. So don't be afraid to say, Your Honor, I'm not sure, but, or Your Honor, that's not in the record, however, and then you can sort of pivot to a strength. But actually, good advice. I forgot that point. Good one. Reed?
Yeah, no, great job overall, guys. I thought you all were easy to follow, easy to listen to for the most part. One pet peeve, if the court is speaking, and the court being Ashley, Josh, and I, don't speak over the court. The moment you see the little yellow box, the moment that a judge is talking, just shut your mouth and just stop and listen to them, because The court wants a question answered, and if you're speaking while the court is speaking, nobody knows what's going on. Additionally, listen to the questions that are answered and actually answer them. If a judge asks, "Is the sky blue?" then that's a yes or no question. Yes, Your Honor, but. No, Your Honor, but. If the judge asks, "What color is the sky?" you reply, "The sky is blue." You see, listen to the difference in those questions, and you'll be able to be much more responsive to them. Yeah, and other than that, I don't have anything. Good job, everyone.
Awesome. Well, I'm proud of you all. Do you have any questions for us or anything that you want to ask us? About law school, about the competition, whatever you want, open game. We ask you questions now it goes back the other way.
I appreciate the advice that you guys gave. Do you guys have any other advice, particularly for law school, like something that's the most helpful?
Oh, sure. It's a hard question. Now, you guys sophomores, juniors, seniors, what year are you all?
I'm a junior.
Junior,
Junior.
junior,
I'm a sophomore.
sophomore? My goodness,
Yes.
these sophomores.
Yes,
Okay.
sir.
When I was a sophomore, I didn't know anything. Right. So I guess you're in the process of looking for colleges now, thinking for next year that's on your game plan. Right. So it's a hard question. We often get this, what's a good major if you're thinking about law school? And the answer is really not one right answer. Right. Some people try and do pre-law, they might do political science. I didn't have that major. My friend Ashley didn't have his major. Reed did major in political science, but there's a lot of different ways you can do it. Most colleges have strong mock trial programs, moot court programs. Try it. See how you do. They have tournaments. You can compete. You can travel. You can go to different places and try and see other people. One piece of advice may sound silly, but it's important, is learn how to write. The most important thing about being an attorney is not speaking. Speaking is fun, right? But writing is what makes our money. That's where we get our credit. So whatever you do, learn how to write. And I read your briefs. Your briefs are good. I mean, you're 16, 17 years old. Your briefs are good. But you can always become better at writing and making your writing tighter and not using flourish. Try and get very clean to the point. This is a tip I use. Don't use adjectives or adverbs. I never use them ever, right? Because they're lazy. When you use an adjective, you're not actually describing what you're thinking. You're just saying, well, this is unreasonable. Well, why is it unreasonable, right? Give words to describe what you're thinking instead of just adjectives. And also with an adjective, it can let you show your personal opinion much more cleanly, right? Because if you have very negative adjectives like, this is a terrible idea. Well, why is it so bad, right? You're giving away your opinion versus this idea should be rejected by the court because of X, Y, and Z. Oh, you see that, right? Now you're actually giving reasons, not just saying it's a bad reason. Anyway, that's my thought. I don't know, Ashley, you guys are closer to college than I am.
Yeah.
What do you guys think?
I definitely emphasize the writing thing. And I know y'all aren't in Texas, but I went to high school in Texas and we had this program where you could take college classes in high school. And unfortunately, I thought that was a good idea. I took all my writing classes for college, my junior and senior year of high school. So when I started law school, I hadn't taken a writing class in 4 or 5 years.
Was that right?
And it was so hard to learn how to write again. And I mean, yes, it was easier in college for me not to have to take these core writing classes, but I regret it so much.
Oh, that's so interesting. I didn't know that. Yeah.
So yeah, I would highly emphasize taking a core writing class if you know that's what you want to go to law school. Just try to focus on that in college because it'll make your first year of law school way easier.
Oh, that's fascinating.
Or I mean, I took my writing classes in high school as well, but because I was a political science major, everything I did was writing essays. And so I was writing all 4 years, and it just got easier over time. And then the stuff I was doing in law school makes all that look like garbage. It's just getting reps in is all it is. And to become a good writer, I think you have to read good writing.
Yeah.
So I know Brian Garner, who's the guy on legal writing, says read The Economist. The Economist is great. It's a magazine. Wall Street Journal has good stuff. But if you're constantly consuming good media and good writing that challenges you and uses good sentence structure, etc., that really helps. One piece of advice that's very easy to say when you're an undergrad, have a good GPA because it makes everything so much easier when you're actually applying to law school.
Yeah, they're smiling.
Keep your grades up. Keep your grades up, and then towards the end of college, find a good LSAT prep if you're thinking about law school, and really put the work in. And you doors will open for you. You're already doing stuff like this. This is ridiculous. This will look so good.
Put this on your resume. You're all semifinalists. Put this on your resume.
Yes.
You're all semifinalists. You already. I mean, you already won. I mean, you already advanced the next round. That's not easy. All right.
That's all I have.
Yeah, no, that's great. I mean, you're all here today. You advanced the semifinal round. That's in your resume, right? That's something you can put on your record. What else? What else do you want to ask us? I know it's like a huge field, but anything else in your minds?
Did you all take any law internships or have any recommendations for whether you might need to or it's good?
You're talking about before law school?
Yes.
When I was in college, I actually interned for an attorney who was in town. This was somewhat obscure, but one of my professors knew an attorney in town. He needed a research assistant, and I worked for him for a few weeks. I don't think I paid very much. It was not much, but it was a good experience. I was doing research on credit scores, which sounds kind of boring, but it was something he needed help with. And I got a lot of very practical experience, even talking to a lawyer. If you have lawyers in your family, or if your family knows lawyers, just ask to like work in their office for like a few weeks over the summer. And even if you're just, making copies and just sitting on meetings, you're going to learn so much, because you guys are like sponges. I can just see just looking at you. You're sucking in everything we're saying, right? Which is good. Just ask like, could I spend a few weeks over the summer for a few hours a day just sitting in your office? If they're doing like a deposition, just to watch a deposition being taken, or if they have to go to a trial. One of the other tip of advice: courtrooms are open to the public. Actually, with COVID, I don't know if that's true anymore, but in theory, at least, any courtroom in the United States is open to the public. If you guys, so you guys are in Maryland, I think you guys are in Pennsylvania. If you just Google where the nearest courtroom is and you just check their calendar, like they usually post a calendar online, and you see, okay, the docket calls at 9 a.m., just go at 9 a.m. and just sit there in the back row, see what's going on for an hour, right? If you want to go to a criminal court, you maybe see a trial for criminal law, right? Maybe you'll see a defendant pleading guilty to a crime. Maybe they'll be hearing whether you exclude evidence because it wasn't properly obtained. Maybe go to a probate court, see people fighting over a will or fighting over a custody issue for children. Like, I'm not being facetious. Every court has open seating, and your courts may even have Zoom. Like, you just have a link to watch it on Zoom. So, I mean, that helps you get off your couch, right? But just watch it and you'll learn so much. I love whenever I go anywhere to just sort of walk into a court and see what's going on there. And it's free. You don't need an excuse to go. You can just walk in and say, hi, I'm a student. And they'll say, oh, hello. And then that's it. All right. What other questions you guys have? No? All right. Well, we have another round coming up in a few minutes, so I will need to say goodbye. But you have my information. If you want to email me or read or ask, we're happy to field your questions. So thank you all so much. All right. Take care, everybody. I'm going to stop the recording now.
Thank you.
Thank you so much.
Thank you.